Can I file a state law breach of contract in an ERISA disability claim? Did you know that suing for a breach of contract might not be an option if you are covered under an ERISA disability policy or plan through your employer? That answer might surprise you, especially if you're navigating the frustrations of a denied or terminated claim. So let's unpack the details. What happens if you buy a private disability insurance policy? Now, in that case, most likely your case is going to be governed by state law. And you can sue them in state court for a breach of contract because you entered into a contract with the disability insurance policy plan or carrier directly. Now, but what happens if your disability insurance is part of a disability policy or plan provided by your employer? And this is where a federal law known as the ERISA Act, Employer Retirement Income Security Act, comes into play. What is ERISA and how does it affect your claim? Well, the short answer is it's not a good place to be. Employer-sponsored welfare benefits are governed by ERISA, including disability insurance. And unlike private policies, ERISA will severely limit what you can sue for and requires that lawsuits be filed in federal court. If you try to bring a state law claim, such as a breach of contract claim, you're likely going to face a significant roadblock. They're going to argue something called preemption. So let me explain this in an example. This is the case of English versus Lincoln Life. English sued Lincoln Life alleging a violation of ERISA and a breach of contract. He had a disability policy through his employer. Now, was it governed by ERISA? Yes, it was governed by ERISA. Lincoln Life responded by filing a motion to dismiss the breach of contract claim, arguing that it was preempted by the ERISA statute. And the federal judge agreed. The court ruled that ERISA expressly preempted state law claims that related to employee benefits. And this includes claims arising from how the plan or policy is administered or how that claim is processed. What does ERISA preemption mean for you? Well, if your disability insurance is governed by ERISA, here's what you need to know. 1, there are limited legal remedies. ERISA preempts state law claims like breach of contracts, so you can't sue for emotional distress, punitive damages. Your remedies are going to be limited to unpaid benefits, interest, and maybe attorney's fees if you're successful in front of the court. Number 2, federal court jurisdiction. You have to file your lawsuit in federal court. State courts don't have jurisdiction over ERISA claims, and if you file it in state court, they're going to remove it to federal court. Thirdly, the administrative process is completely different. Before filing a lawsuit, you have to exhaust the appeals process, and the failure to do so could result in the dismissal of your claim. So, lessons learned: if you have an ERISA plan, understand that state law claims are like breach of contract claims. That's off the table. Next, you need to familiarize yourself with limitations and the requirements of ERISA, including the mandatory internal appeal process. And 3, you should be working with an attorney who's experienced in ERISA law to navigate the complexities of the ERISA claim. ERISA preemption can feel frustrating, but I think knowing the rules can help you avoid unnecessary legal setbacks. Call us at 727-894-3188 to discuss this complicated area of ERISA law.